Welcome to week 2. This week we're looking at federal inspections for the USDA FSIS, the Food Safety Inspection Service, which is the inspection arm of the USDA, and the FDA. FDA traditionally would be thought of as having the Office of Regulatory Affairs as being the inspection arm, and the Center for Food Safety and Applied Nutrition acting as sort of a subject matter expert for the RFA. That is changing. The regulatory model for FDA is moving away from the ORA under a reorg. So right now we'll just talk about FDA versus FSIS as they're comparing and contrasting. And I think comparing and contrasting is the most effective way to take on this topic of federal inspection models. We have two food agencies, the USDA, the FDA. And generally speaking, we can say that the USDA is in charge of meat products. We have the Federal Meat Inspection Act, the Poultry Plant Inspection Act, Egg Product Inspection Act, we have the Humane Slaughter Act, and we have some others. It's really important, and there's a discussion in the textbook to delineate what is meat versus what is not meat. And that's going to be really important as we go forward because these regulatory approaches to inspection are so different that if you're in the wrong classification, you think you have a meat product, then you're going to be subject to something very different than if you didn't have a meat product. And understanding that dual jurisdiction for a facility that does both USDA FSIS products and FDA products. So when we talk about the FSIS inspection model, I think the shortcut, the shorthand way to think about this is that it is mandatory, it is continuous. And it's different than the FDA in the way that the slaughter and production of meat is not a right. You have no right to engage in this business. And I think that can be something that's a little bit surprising because when we think about FDA and we think about food and dietary supplements, we think of it just as starting a business. There's no barriers, there's no real thought to it. If you want to do this and you come up with a product that's innovative, go for it. Very different on the meat, slaughter, and production. You have to apply for a license to engage in this type of activity. You have to have USDA FSIS on site, continuous every time that you want to have production running. And with that comes stronger regulatory controls that are preemptive. The escalation of actions can be much more severe. Going from something very simple like having product reprocessed, refused, the marks of inspection refused, to something more severe like having the inspection authority withdrawn, effectively closing down a facility. And that's something that's very different, as we'll talk about. So the FSIS inspection model is both continuous, mandatory, but also much more in terms of how it can pack a punch. The FDA inspection model is very different. We do not have to have FDA inspection people or agents in the facility to operate. It's essentially random. We have two types of inspections that can occur: a for-cause inspection. If there's an outbreak or there's an adverse event that's being investigated, the FDA can have what they call for-cause inspection, where they're looking for the source of that outbreak, for example. It can be a surveillance inspection. The FDA is supposed to get to facilities on a certain basis. Resources, personnel limitation limit how often that can happen. It's often disconnected. We are not in the facilities and intimately familiar with what your products are, what your operations are, who you are as a business that the FSIS may have. It's a district or field office. It's an agent that may be doing something with your facility on a basis every 5 years or even further than that. Prior to FSMA, we had very few mandatory enforcement tools. That gap of enforcement tools is getting smaller in a way with FSMA between USDA and FDA, but it's not significant. The FDA has authority for mandatory recalls, for example, but otherwise they need to go to court to try and get an action to happen, like a suspension of a food license, something like a seizure or injunction. Those involve the court, and that's very different than the USDA model where they can see a violation and take a regulatory action immediately. So one way we can think of the difference between the FDA and the USDA is the USDA FSIS is a proactive model. preemptive, and the FDA is largely reactive. It's once products enter the market and there's an issue, then we're going to have the FDA come in. Now we have different tools that the FDA can try and bring voluntary compliance proactively in place, but it's just not the same as the USDA. So it comes down to the question of, is one inspection model better than the other? Is there a scientific rationale for one over the other? And there's an issue because the FDA's inspection reach is reaching less than 3% of facilities. And sometimes this number is shown as high as 5%, or in some cases I've seen it 7%, but I don't think it's a significant part of the FDA in terms of the total industry it gets. And the FDA does have a wider mandate, and maybe that's an issue. The FDA on average will do about 2,000 to 4,000 inspections a year, from very small to very large, but it's a huge industry, everything from canned soup to seafood. It's massive. The FDA inspection gap is about 7 to 10 years. The goal is always to make that smaller. FSMA is bringing in some tools to try and bring in higher risk facilities into more frequent inspection. So we kind of have to ask ourselves, if we were to pick one of these models, mandatory versus random, proactive versus reactive, which we would prefer, and does it concern us that there are differences based on food? Is meat more risky than seafood or juice or canned soup or ready-to-eat pizza products that don't contain meat? Is there a scientific reason that we would say, okay, I think that the USDA model makes sense because this food has these risks? Or is the USDA food less risky? Yes, chicken will contain salmonella, but chicken should be cooked to a certain temperature for a certain period of time and control that risk. So it's something for discussion to look at. With all of these inspections, there are constitutional questions that come up. We have the Fourth Amendment, which protects against unreasonable searches and seizures. And this is more of an issue in FDA facilities because, again, we feel in some ways with FDA facilities that we have this right to be in this business, and we're operating without the FDA, and suddenly the FDA shows up. They have a Form 482 demanding entry into your operations, to your facility. To refuse them is a misdemeanor. So there's this warrantless inspection that's occurring. Different than the USDA, where we know we need to have a license to have these FSIS agents in the facility for operations. So we usually think of this constitutional issue as an FDA. There are exceptions to warrants. Government agents can obtain a search warrant as a fallback. So you could refuse the FDA and say, get a search warrant, which they could easily do. So we have this Fourth Amendment issue. Do we feel comfortable with warrantless inspections? Do we feel that the FDA should always get a warrant? It's a good question to be asking. There's a few ways that obviously we have gotten past this constitutional issue. We've had the FDA inspections for a very long time. The Factory Inspection Amendment specifically gave that authority to do that. Presented in the textbook is some examples of where the constitutional issues can be lost. Giving consent, that destroys the Fourth Amendment. We have pervasively regulated doctrine. What we'll see often with the FDA is they will look at other administrative agencies, OSHA, EPA, and Alcohol and Tax Bureau, for example, and look at those and say, well, if they're permitted to do it under case law or challenges that have happened, then we can do it too. And what we often see in industry is an effort to try and get along. We don't want to get on the FDA's wrong side, so we'll consent, we'll know that they can get an administrative warrant, and we'll go along with it. What's become really important in this process is not so much the constitutional issues anymore, but that we have the FDA Form 42 properly presented, that we have the proper training so someone doesn't accidentally refuse an inspection. We now have the Form 43, which has become very infamous. Prior to this amendment, we would just have the FDA show up, they would leave, and then maybe notify of an enforcement action several months down the road. So the broader constitutional issue maybe isn't as important anymore because we know the FDA can come into the facility and conduct an inspection. But there are constitutional questions that we can still ask about new ways the FDA can come into the facility. So can the FDA fly over your facility with a drone and take photos or take video of what was happening at the facility. Can the FDA come in and take photos and video? Very easy to do now. Maybe something as simple as taking photos of swab sites that they're using, but maybe they take a video of the entire inspection, and that way if there's a particular reaction or type of question that's asked and you answer it in a certain way, then maybe that's given some weight or some consideration. Technology is continually moving, and the constitutional questions remain, and there haven't been any constitutional challenges. So what we may see under FSMA is we have more inspections, or there's more penalty or consequences from inspections, that these issues are eventually challenged directly. And we're using old case law with brand new technology, which poses all kinds of issues. So one of the important pieces is maybe not as much the Constitution. As it comes to these issues down the road, it could be important. But we have the Administrative Procedures Act, which asks that the FDA be consistent, and all agencies be consistent, the USDA as well, be consistent in how they're applying the enforcement actions. So they can't say, well, I don't like you, so I'm going to enforce it this way versus I like this other facility. They give me some perks or some better feeling. The FDA does have to be consistent. All agencies have to be consistent. There's also questions of, are you creating new rules as you go along rather than going through this procedure for rules? And that can be something important as we look at challenging these inspections or the findings of these inspections. For the FDA, the biggest fallback that we have in terms of protecting ourselves in an inspection is the factory inspection broadly requires that the inspection be reasonable. And is it reasonable to take swabs? Is it reasonable to go to all areas of the facility? There's restrictions on records, but beyond the restrictions on records, what else is reasonable? And that's what we can come to whenever we're trying to confront an inspection and see, are they going too far? And the last topic that we have that is sort of an interesting one because it gets used so much by the FDA is this use of warning letters. Again, this we don't see in the FSIS model because there's no need to warn you. You just know that if you're hitting certain triggers for these regulatory controls in FSIS facility, that they're going to be linked to consequences. So it's very clear in an FSIS facility, you hit a trigger, there's a regulatory control. You can hit it again, there's another regulatory control that escalates the penalty. The FDA, however, doesn't have that approach. We have a Form 43. If you don't respond correctly or the FDA doesn't feel that you adequately address the issues raised there, they can go to a warning letter. But the warning letters are seen as weighty and serious, but in reality, as we see in the text, they're not subject to challenge because they're unripe. The FDA is basically working to coerce facilities into compliance without actually having to take actual compliance efforts. And the FDA doesn't even consider these to be compliance efforts. So that kind of summarizes the difference in these two approaches. The FDA has to work on veiled threats and coercion to get facilities to comply, whereas with an FSIS facility, you want them in your facility, you want your facility to continue to operate, then you need to be aware of the regulatory controls, be aware of the triggers for those controls, and don't escalate an issue to the point of withdrawal. Very different from what we see with the FDA. So hopefully this has been a good summary of the Federal Inspection Authority. Key differences, and we can talk about whether those differences make sense and should be an area of concern or an area of, I guess in a way, comfort that we have this difference.